The use requirements in Turkey and submitting evidence for proving the use of a patent are the subjects about which we receive questions from our clients the most. New IP law abolished the provisions concerning the use requirement of patents and evidence on use detailed in the decree law on the protection of patent rights. In this video, we will talk about the use requirement within the provision on compulsory licenses as a consequence of non-use of a patent according to the new IP law. My name is Burcu Sucuka and I'm a senior patent attorney at Gün Plus Partners, specialized in patent prosecution and litigation for 10 years. The new IP law numbered 6769, which has entered into force on 10 January 2017, abolished the provisions on the use requirement of patents and the evidence of use of the decree law on the protection of patent rights. The law now focuses on the requirements of use for patents within the provision of a compulsory license. Accordingly, a patent owner must make use of the patented invention within 3 years following the publication of its grant decision in the official bulletin, or within 4 years from the date of its application, whichever is the latest. The patents that are not declared to be used within the period prescribed in the law by Article 117, paragraph 8 of the Regulation on the Implementation of the IP Law are published in the bulletin. The bulletin is a type of announcement that is made when a patent has not been used. Third parties are then aware that they may request the license over such a patent. For European patents, the bulletin is the European Patent Bulletin, and the date triggering the 3-year period is the publication of the mention of grant of the European patent. When assessing actual use, market conditions, and conditions outside patent owner's control, such as the need for pharmaceutical marketing authorization, compliance with standards, and the lack of new applications in alternative fields should be considered. At the end of the prescribed terms, any interested person may request a compulsory license on the grounds that the patented invention is not being used, no serious and real measures have been taken to make use of the patented invention, or that the level of the current use does not meet domestic demand. The same applies to cases where no use of a patent has been made for more than 3 years without justified reason. Additionally, patent holders are requested to file a declaration of use of the patent with the Turkish Patent Office. The regulation on the implementation of the law rules that the declaration of the use of a patent must be submitted to the office under the same legal terms as prescribed in the law. In 2020, the office simplified the said declaration by marking the button that the patent is or is not used in its online system. Therefore, there is no need to submit an actual declaration before the office. Patents that have not been used within this period will be published in the bulletin. The publication, however, does not lead to any direct benefits or negative consequences. Even if a patent is not listed as a non-used patent, a third party may still request a compulsory license, claiming that the patent is not used or that no serious and real measures have been taken to make use of the patented invention, or that the level of current use does not satisfy domestic demand. Even if the patent is listed, it does not mean that a compulsory license will be automatically granted. It is always possible to declare the patent is being used even after it is listed as a non-used patent. You can find more information on this topic in our thought leadership paper for this year. Thank you for listening to me.